Welcome back to Organize, the business law breakdown, where we make corporate law less boring and maybe more useful. I'm Professor Seth C. Oranburg, and today we're diving into one of the most controversial topics in corporate governance, executive compensation. Some CEOs make more money than the GDP of small countries, and they get massive bonuses even when they screw up. And it's almost impossible to claw back their pay, no matter what they do. So what's really going on here? Let's talk about CEO pay versus actual workers. And let's start with some numbers. Way back when dinosaurs roamed the earth, in 1965, the average CEO made 20 times what the average worker earns. By 2023, that number was over 300 times. And at some companies, it's over 1,000 times. For example, in 2022, Amazon's CEO made $212 million. That's 6,474 times the pay of Amazon's median worker. Is that fair? Is that unfair? Whatever you think about it, it's legal, and today we're going to talk about why. So who decides how much a CEO gets paid? The board of directors, specifically the board's compensation committee. Under Delaware law and the Model Business Corporations Act, boards have broad discretion to set executive pay. And that means there's no law saying CEO pay has to be quote-unquote reasonable. A reasonable CEO pay is whatever the board thinks it is. If a board thinks an executive is worth $50 million a year, even if the stock price is tanking, courts will usually defer to that business judgment unless something shady happened. So let's talk about something shady. And let's go back to the Michael Ovitz story and the $140 million severance check. We touched on this one a few times, but let's go deeper. In 1995, Michael Eisner, Disney's CEO, hired his friend Michael Ovitz as the company's president. Ovitz had never worked at a public company before, and he was terrible at his job. Disney's board fired him after 14 months and then handed him contractually required $140 million severance check. Shareholders were furious because effectively that's their money going to this guy. So they sued the board. They argued they breached their fiduciary duties by approving such an outrageous contract. And in 2006, Delaware Supreme Court ruled in favor of the board. The court said the board acted in good faith, the business judgment rule applied, and courts don't second-guess dumb business decisions. Translation? Boards can pay executives whatever they want, as long as they follow proper procedures. What about shareholders' say-on pay? Wait, might you be wondering, don't shareholders vote on CEO pay? Well, yes, but also no. After the 2008 financial crisis, Congress passed the Dodd-Frank Act, which created say-on pay. This means shareholders get to vote on CEO compensation. That sounds like a big deal, right? Except, yeah, the vote is non-binding. So if shareholders reject an executive pay package, the board can ignore them. And they often do. Let's talk about Elon Musk. In 2018, Tesla's board approved a record-breaking compensation package for Musk. If Tesla hit certain milestones, he'd get up to $56 billion in stock options. This wasn't salary. It wasn't guaranteed cash. This is pure stock-based incentives. I'll tell you something really weird. Shareholders voted to approve it, but one, Tornetta, really didn't like it. And in 2024, a Delaware court struck it down, even though shareholders had approved it. A judge in Tornetta v. Musk did not say that Musk was paid too much. Instead, the ruling focused on procedural flaws and how the Tesla board approved the deal. And it particularly focused on this idea that Musk was a superstar, which is not really a concept in corporate law. Anyway, the court ruled that Musk had outsized influence over the board, and as a result, the Tesla directors weren't truly independent, and therefore they didn't properly inform the shareholders, who were under some kind of hypnosis, I think. The court ruled that Tesla had to cancel Musk's $56 billion pay package because the process was flawed. This was a huge decision, and it prompted Musk to move his company to Texas, which wasn't so great for Delaware. And Delaware ended up passing Senate Bill 21, which would effectively have reversed the decision. But for the first time in years, Delaware courts actually rejected a CEO pay package based on what they saw as bad governance. Will it change how CEO pay is set in the future? Maybe, but I don't think so. If anything, this would suggest that if the courts don't do what CEOs like, they'll move to another state and the legislature will get rid of the judges or the law. So can anything stop insane CEO pay? Not really. Courts usually won't interfere unless there's clear self-dealing or fraud. And frankly, why should they? It's other people's money. When shareholders vote against CEO pay, boards can just ignore them, but shareholders could sue their stock. If they really think this is a bad deal for the company, they don't have to remain shareholders. So unless we see major changes in corporate governance law, we might expect CEO pay to keep climbing, or at least to recognize that shareholders have very little power over this part of corporate governance. In the next episode, we'll talk about risk management and the so-called duty of oversight. Who pays when no one's looking? Until then, I'm Professor Seth C. Oranburg, and this is Organized, the Business Law Breakdown. I'll see you next time. Welcome back to Organized, the Business Law Breakdown, where we cut through corporate nonsense and get to the rules that actually matter. I'm Professor Seth C. Oranburg, and today we're asking, what happens when a company, totally screws up? I'm talking, major scandals, billion-dollar fines. People die. Things have gone totally wrong. The government, the media, every lawyer within 150 miles is ready to pounce. We're talking about risk management and why courts now say that corporate boards have to keep an eye on it. We'll also talk briefly about whether this is a separate duty that emerged, the duty of oversight, or whether this is part of the duty of care or loyalty. So who's responsible when a company fails? Once upon a time, corporate directors had a job. Don't steal from shareholders. And that was pretty much it. Courts didn't care if they ignored obvious warning signs or let management run wild or sign merger agreements while drinking a couple martinis. But in the last few decades, that changed. Now directors must oversee risk. They have to ensure the company has systems in place to detect fraud, prevent disasters, and comply with regulations. Because if they don't, they can be held personally liable. I mean, at least sort of. There's all kinds of provisions that give them insurance and indemnification, exculpation, but technically, they can be held personally liable. And some call this the duty of oversight, and it comes from a famous Delaware case with a name which is very apt, In re Caremark International. So it's the duty of Caremark. Yep, Caremark. Caremark and the duty of oversight. So Caremark was a healthcare company, now Caremark CVS, and it got caught bribing doctors. Oops. Kickbacks, not so cool. Wildly illegal? Yes. Scandal came out. Shareholders sued directors. The argument was the directors failed to prevent the company from breaking the law. At the time, this was a new argument. Do directors actually have to prevent a company from breaking the law? Does the duty of oversight include any kind of duty of obedience to the law, or even a duty to monitor? Or is it just an affirmative duty not to do something so freaking stupid that it's gross negligence or recklessness? Well, the Delaware Chancery Court said that boards can't just be passive. They have to actively monitor for corporate compliance, and if a board totally fails to oversee risk, they can be liable. This became known as the Caremark standard. And this is when risk management gets real. In the case of Marchand versus Barnhill, we can fast forward to 2019, and this is the ice cream case. We get another landmark risk oversight case that continues to reinforce this lesson. So there's a company called Bluebell Creameries, and they sell ice cream, and the ice cream makes people die. There was a massive listeria outbreak in 2015. 3 people died, and the FDA found that Bluebell actually knew about listeria contamination for years, and it kept selling the ice cream anyway. Shareholders sued because when you kill people with your ice cream, that's cost your stock value a bunch of money, and the shareholders sued, arguing that the board failed its duty of oversight. Like, you should have noticed if there's toxic stuff in the food you're selling. And in this case, the Delaware Supreme Court agreed. The board never discussed food safety in their meetings. Oops. They had no system to monitor product contamination. Oops. They ignored warning signs for years. Triple oops. This was the first time the Delaware Supreme Court actually held directors liable under Caremark. So the message is pretty clear. If you run a business where health and safety are critical and you ignore risk, you're on the hook. What about cybersecurity? Or even artificial intelligence? Or environmental and social risks? Today, oversight failures aren't just about food poisoning and bribery. It seems that directors also have to manage data breaches, hacking, ransomware, climate policies, DEI initiatives, algorithmic decision-making. Let me give you an example. In McDonald's Corporation stockholder derivative litigation, a 2023 case, this was the first case where a corporate officer, not just the board, was also held to a duty of oversight. Why? The company's chief human resources officer allegedly ignored years of sexual harassment complaints. And the court said, directors and officers can't turn a blind eye to misconduct. So if you're in charge of compliance, risk, or safety, you could be liable too. And I mean that personally. The bottom line is boards can't ignore risk anymore. To sum up, boards can no longer be asleep at the wheel. Caremark established a duty of oversight. And whether you characterize that as the duty of care, the duty of loyalty, or something new, you have to monitor for ongoing risk. Marchand proved directors can be actually held liable, because they were. And today, this applies to cybersecurity, AI, and even social issues like ESG and DEI. In the next episode, we'll talk about the limits of corporate governance. What happens when directors themselves are the problem? But until then, I'm Professor Seth C. Oranburg, and this is Organized, the Business Law Breakdown. I'll see you next time.